Please remain seated. Okay. Our final case for the day is Altamont Springs Acquisition, 172596. And whenever the appellant's counsel is ready, you may proceed.
Thank you, Your Honor. And if it pleases the court, Judge, I represent the appellants in this case, and there's a number of them. It's Ms. Elliott and et al. And what we're asking the court to do is to take a look at Article 17 of the Declaration of Condominium and reverse the lower court's finding that, in fact, there is a number of ways to terminate the condominium, and they are in subsection A and subsection B. And, Your Honor, our argument is based on the reading of Article 17 specifically, and we submit to the court that the lower court misinterpreted that particular provision of the declarations because it basically created a right to terminate the condominium that does not exist. Specifically, subsection A has to do with the election to terminate the condominium. That is the principal concept and the principal purpose of Section A. Section B is totally different from the termination. It's basically an option to purchase the units of the other condominium owners other than the 75% or 80% that want to elect.
Was it your position that to terminate a condominium, you first go through A and then you go through B?
Yes, Your Honor.
And their position is A is one option and B is one option?
Yes, Your Honor. And the problem with their interpretation, if you look at B, it clearly says that it's the option to purchase the other units. That is the subject matter of subsection B.
But under A, 100% agree to terminate, and your argument is some type of pre-termination period of time, pre-termination phase.
Well, I concede that it's poorly worded.
Right,
it is not an easy thing to read.
But if A comes first and B comes second, then A would be some type, the unit owners vote to terminate, and then they're in a pre-termination phase until B happens. Is that what you're saying?
Yes, with a qualification that you don't elect to terminate under B. You still elect to terminate under A. The wording is very clear. Subsection A says in order for the condominium to be subject to termination, you have to have unanimous consent of all the unit owners plus the mortgage holders. I mean, they basically concentrate on the way to terminate a condominium. You've got people gathering together to form a condominium with different rights. They have mortgage holders that have liens over those property, and they're saying, okay, this is the way you're going to terminate. There's going to be two ways. The first one is going to be you unanimously agree, including the mortgage holders. They're conceding the fact that the mortgage holders have a vested interest in terminating the condominium. And you can do it that way with the unanimous consent of the owners and the mortgage holders, or you can do it based on major damage. And major damage is something that was really not an issue in this proceedings, and that's why I mentioned in my brief that it's really not appropriate. But it kind of helps. It helps because when you look at the provision of the reconstruction or repair after casualty, which is Article 15, and you talk about major damages, there it reinforces without equivocation that, in fact, they refer to an agreement to terminate. The only provision in the condominium declaration for an agreement is subsection A. There's nothing in subsection B talks about any kind of an agreement.
Well, let me go back to your argument. So if A happens and 100% of the unit holders and mortgage holders all agree to terminate, and then you go to B, how do you determine which 75% buy which 25% out?
Well, that's where I think it was inartfully drafted, this particular provision, because first of all, look at subsection B. It has nothing to do with termination. It has to do with stated fact. They're referring to having elected to terminate. In other words, if the owners of at least 75% of the common elements elect to terminate, so it's a fact. It's whether they did or they didn't elect to terminate. It doesn't have a procedure for termination. It doesn't say you're going to follow a particular way of terminating. It doesn't provide for hey, instead of having the unanimous consent of all the mortgage holders and the unit owners, you can go ahead and terminate with 75%. How absolutely ridiculous would that be for the drafters of the declarations to take into consideration the mortgage holder's interest in the property, to consider everybody's interest in the property, require unanimous consent to subject the condominium to termination, and then in paragraph B say, throw that all away. 75% of you guys at any time can get together and terminate. We're not going to tell you how you're going to terminate. We're not going to tell you what meetings you have to have. We're not going to have to tell you, we're not going to tell you the procedure.
What's the purpose of Section B?
The purchase of the other unit owners, the option to purchase. Subsection A is termination of the condominium. And it clearly says, subject, and you got to go through A to subject the condominium to termination. Paragraph B says, if you elect to terminate, the 75% of the unit owners have the right to purchase the other unit owners. It's a right to purchase.
Well, no, I mean, it says 75, if at least 75% of the common elements elect to terminate. So why would, here's what I'm struggling with. So you have paragraph A that says, to start this whole process, under your interpretation, to start this whole process, you need 100%. Then we get down to B, and you say, if at least 75% of the common elements elect to terminate. So, but wouldn't it, when would there be 100% of the owners and lien holders that elect to terminate under A, but you don't have at least 75% of the common elements elected to terminate?
That's what's awkward about that's what throws people off reading this particular section. That's why it's important to go back to Article 15. If you go back to Article 15, Judge, it talks about, and if I could, and it says major damage. And it says, if the damage improvement is to more than one building, and if apartments to which more than 50% of the common elements are found by the board of directors to be not tenable, then the damaged property will not be reconstructed or repaired, and the condominium will be terminated without agreement as elsewhere provided, which clearly refers to subsection A, unless within 16 days after the casualty, the owners of 75% of the common elements agree in writing to such reconstruction repair. Now, it doesn't say it as clear as we would like it to say, because it could say exactly what subsection B says. But if you construe it, and you have to construe all the paragraphs in the declaration and try to construe them consistent with each other, and not make one in particular a nullity, which would be the effect if the appellee's arguments would prevail. But in this provision, one reinforces the fact that there's an agreement to terminate, because there's only two options to terminate in my construction of the declaration. Major damage or...
So B only applies if there's major damage. Is your position that B only comes into play if there's major damage?
No,
Okay.
no, because it talks about the option to purchase. So the option to purchase, if you terminate the condominium, you're gonna have the option to purchase, except yes, the option to purchase would come into effect after you go through subsection A. So if everybody...
But there's two scenarios in subsection A, correct? There's 100% of the owners plus lien holders, right?
Yes, Your Honor.
And then there's major damage.
Yes, Your Honor.
Those are two separate scenarios.
Yes, Your Honor.
So does B come into play with both of those scenarios or only with major damage?
I submit to the court that it probably comes into play on both scenarios.
Can you explain to me then, and what I'm trying to figure out is, what's the potential scenario, the hypothetical scenario where the first scenario in A, all the unit owners, and then, so you have 100% of, everyone agrees to terminate under A.
Right.
And then you go to B, and what is the 75% of the common elements language? How does that relate to that scenario in A?
That's what I was trying to explain by
Right.
referencing back to Article 15. If you go to Article 15 in the definition of major damage and the way they treat it, they treat it as if requiring that the owners of 75% of the common elements agree in writing to such reconstruction.
But that would
So-
be related to the major damage.
Correct.
Take major damage out of the picture. I'm talking about just 100% of unit owners. There's no major damage. Okay? We're not dealing with a major damage scenario. We're dealing with a scenario where all of the unit owners have voted to terminate. Then you get to B. And in that scenario, what is the 75% of the common elements?
I see. Then my position would be that subsection B would only apply as to major damage.
Okay.
I think, I agree with you. I see your point. And that makes perfect sense. Actually, that's an argument that I should have made, which I appreciate the court noting, and that is because it refers to the 75%. It does relate to Article 15 specifically. And you're
Wouldn't it
right.
have helped? Wouldn't it have been a major help here if that's what this provision actually means? Shouldn't it have said, in the case of major damage, comma, if the owners of at least 75% wouldn't that have?
Yes, it would, and that's what I talk about, the improper or lack of proper drafting in this case, because they don't refer back to Article 15. You kind of have to find it, but I think it makes perfect sense what the court has just indicated.
Do you still argue that the association owns 100% of the common elements? Is that still you made that argument at some point below? Is that an argument you maintain?
That the association owns 100% of the common elements?
Right, that sort of the appellee's interpretation is unreasonable because there's only one owner of the common elements, and that's the association.
I think I was making that argument. Judge, first of all, I don't profess to be so knowledgeable that my interpretation is the only interpretation viable. But with respect to the argument that I was making with respect to that is trying to figure out, because actually Section A is a little confusing because it does say subject to termination, but then it almost turns in the next sentence and says, well, at that point, then everybody becomes a common element owner in their percentage interest. So,
And at some point,
So
but at some
I-
point, you made the argument that there's only one owner of the common elements, correct? Or did I misunderstand?
I did make the argument that prior to termination, that the common elements would be owned by the association.
And so all I'm asking is that argument still in play here, or is that an argument you're not making here on appeal?
The argument that I was making is basically, since paragraph A within Article 17 has a sentence that basically converts the interest in the association into a percentage interest in the common elements, I was trying to then refer it to the fact that subsection B provides for 75% of the common elements, which it can only come about if, in fact, there's been that conversion. So that was my argument.
And are you still, I guess what I'm trying to find out is that argument off the table now? Because Article 3B of the Declaration seems to state that the owners do have an interest in the common elements. It seems to be right there in the Declaration. And if you're still maintaining that argument on appeal, I'd like for you to tell us how Article 3B of the Declaration might play into that.
Judge, if I may. And that you're referring to 3B in the Declaration
I
under
believe so.
definitions? Okay.
It says, each of the unit owners of the condominium shall own an undivided interest in the common elements, and then goes on from there. But
Right.
so wouldn't that indicate that there's not just one owner of the common elements, that all of the unit owners are owners of the common elements?
The way I was viewing it, Judge, is the association actually owns the condominium's common elements. The unit owners do have an undivided interest in that based on their unit, and that is then easily transferable to a common or a percentage interest upon termination. So upon termination, there's no longer the association. Now the property of the association has to be distributed to the unit owners, and at that point in time is where you got the word, or you got the phrase, percentage interest or an interest in the common element. So my position was that this is kind of reinforced the fact that you had to travel through A to get through B, because you would never get to the point where you would have a percentage interest of ownership by a unit owners, regardless of what else the declaration may say, until you have this conversion and the common elements then become the property of the unit owners as opposed to the association.
I think I understand your point now. Okay, thank you.
So in summary, Judge, and I'll reserve whatever time I've got left for rebuttal, unless there's some other questions.
Right now, you have about 5 minutes, and I apologize for not asking you. So you have about 5 minutes left right now?
Okay, Judge, then I'll...
You want to reserve that?
Yes, Your Honor, I will do. Thank you.
Okay, counsel, whenever you're ready.
Thank you, Your Honor. May it please the court. Tom Zender of the law firm of King, Blackwell, Zender in Wormouth in Orlando, Florida, and I represent the Applee Altamont Springs Acquisition, or ASA, as we referred to it for short in this case. Your Honors, Judge Rudisil made his decision based on looking at this issue twice, and we're here today to ask this panel to affirm the final judgment he entered in favor of ASA, through which he found that ASA, under subparagraph B of Article 17, has the right, as the undisputed owner of more than 75% of the common elements, to elect to terminate should it choose to do so. The court looked at this issue twice, as I said, once in the context of cross motions for summary judgment, where both sides came to the court, said this is a legal issue of contract interpretation. There are no material facts in dispute, Your Honor. Here's the case law. We agree which case law governs this and the tenets of construction you should follow. He made his decision and then considered it a second time on motion for rehearing that my friend and colleague...
Counsel, paragraph A, the last sentence, I'm sorry, but the last sentence of paragraph A does, as counsel noted, does seem to anticipate a conversion of ownership of the common elements from an undivided interest to a percentage. It seems to actually expressly say that, which kind of then would make sense then if you were to then roll into B. Well, now we're talking about a percentage of the common elements. What's your...
Sure. So what A is doing is describing what happens to the condominium property after one of the occurrences in A occurs. So the first instance is A is if everyone agrees, all the unit owners and the mortgage owners execute and duly record an instrument of termination in the public record. That, as a matter of law, terminates the condominium. And then the last sentence of A describes how the ownership that previously each unit owner had in the common elements converts to a tenancy in common. That's just by operation of law. So as the court pointed out with Article 3B, each unit owner owns a percentage interest in the common element when the condominium is in place. So if I own one unit, I own 1 1/4%, I have an interest in that increment in the common elements. All A is saying at the end there is describing how that same interest is now a tenancy in common.
Because
you're no
longer a condominium, so you're
Exactly.
a tenant in common, so now your interest is as a tenant in common rather than as a
Absolutely.
condominium unit.
Absolutely. Same thing in the instance of major damage, the second occurrence that's dealt with in A. If major damage occurs under Article 15, if the definition of major damage is met, the condominium's terminated. It says it will be terminated. The out in 15 is if 75% of the owners of the common elements say, hey, we're going to repair this thing.
Let me ask you about attorney's fees. This was a declaratory judgment action.
Yes, sir.
And, your position is the agreement should be interpreted one way, their argument is the agreement should be interpreted in a different way. Has there been any violation or non-compliance with the condominium documents where the termination proceedings haven't really started?
Oh, I understand what you're saying. In other words, have we triggered the entitlement to fees?
Right.
It's an interesting question, Your Honor. We haven't litigated that yet below. We both sought fees in this court as well. I think if the court were to affirm and remand, the trial court would then determine whether or not a violation under the declaration had occurred based on their position that we don't have the right that we say, and this court would say if you affirmed, that we do have to terminate. So, the language of the declaration provides for fees if they take a position that's contrary to the rights in the declaration, and we're certainly arguing that that's the position they've taken in this case.
Right now, your 75% owner hasn't offered any money to them or anything like that? Because you're in this situation where you're arguing over how the agreement should be interpreted.
Yes, sir. At this point, we haven't conducted the meeting and elected to terminate. Instead, we took a much more conservative approach, which is just to file a deck action and ask a court to tell us whether we had this right or not.
My question goes to both y'all's motions for attorney's fees.
Yes, sir.
Because it's a deck action and we're not in a position where someone's offered money saying, you have to accept this under subsection B, you have to accept it and sell it to me. We're not there. We never got there yet.
Mm-hmm. It's an interesting point. We haven't litigated that, and maybe the trial judge would find that it's not ripe yet for an award of attorney's fees. But we, obviously, to preserve the entitlement, made the argument that by taking the position adverse to our rights under the declaration, you've triggered that liability. So that's why we asserted the claim. So
what's the difference, if any, to owning 75% of the common elements to owning 75% of the units?
there isn't one. If the condominium is in place, as Article 3B makes clear, if you're a unit owner, you own a percentage of the common elements. And I think that further underscores why B can't be a follow-on to A. A talks about terminating the condominium, and if one of those two things happens, it's terminated. If you record an instrument in the public record terminating, it's terminated. If major damage occurs and there isn't a vote of 75% or more of the owners to fix it, it's terminated. In B, it starts out with the proposition that 75% of the owners of the common elements exercise this right. There aren't owners of common elements if the condominium's already been terminated. So that's another indication, I think, a clear indication from the language that A is not a precondition or a condition precedent to B. That just doesn't make sense in our view of the plain language of the agreement, which of course that's the task for the court, right, in your de novo review of this situation, to look at the language that the drafters used, apply the ordinary meanings to the language, give meaning to all of the provisions, and reach a conclusion about what it means. And we think our interpretation is the only one that does that, and it seemed evident to me, based on the questions with my friend, you see the flexibility in their position. I mean, he's done a great job constructing this language in a way to try to meet the interpretation they want, but you shouldn't have to do that.
The provisions could have been drafted more clearly, right?
Well, this litigation's probably the best evidence of that, I guess. I mean, if we could take another crack at it, I certainly would. But the language that we have certainly supports the interpretation that Judge Rudisil reached, having looked at this twice. And it does give meaning to all of the provisions, including 3B, including Article 15, including both A and B of Article 17. All of the provisions in the Declaration have meaning under our interpretation. It's just a recognition, B, of the supermajority's right to take action. Just like in Article 15 with major damage, the supermajority can take action and repair the property and save the condominium. So that is our position. Based on the tenets of construction that we cite in the case law, the same case law that Mr. Benitez cites, we believe that Judge Rudisil made the correct finding, and we ask this panel to affirm that.
Thank you, counsel.
Mr. Benitez, same question I had
Yes, Your Honor.
for your opposing counsel. You've both filed motions for attorney's fees. I believe the documents refer to noncompliance with the agreement or violation of the condo docs.
Yes, Your Honor.
Do we have either of those here, regardless of who
No, Your Honor.
prevails?
And that, I've kind of looked at it, and I've kind of scratched my head trying to figure out how you could get attorney's fees under the declarations, the way they're written, mostly since we're in a declaratory judgment proceeding. And I don't believe, that's my personal opinion, but I did react with a motion for attorney's fees in this case, Your Honor. So if in fact he's correct and I'm wrong, then we're entitled to attorney's fees. but being asked that question, that's my honest answer. And Judge, maybe I'm not explaining myself correctly with Article 17 based on the questions that you've asked, but Article 17, subsection A, the words in subsection A are very clear and unequivocal. It says, before the condominium can be subject to termination, and they use the word subject to termination, one of two things have to happen. There has to have unanimous consent, or there has to be major damages. That is clear. Then you go to the next section, and the next section says, if the owners then elect to terminate. That's an election to terminate. So one of the readings that I proposed in, I believe, the initial brief was that you got to travel through A to get to B, because you've got to have the permission first under A to subject the condominium to termination. There wasn't a right just for 75% of the owners to get up and decide that we're going to terminate the condominium. Mostly when the drafters went back and specifically said in A, not B. A normally comes before B, so you read A first before B, and they're asking you to read A, and it says, shall be deemed subject to termination if A is complied with. Why isn't it important to go ahead?
That does make it sound like it's not a done deal, right, at that point,
Right.
that language. However, the rest of that sentence is, and therefore owned, and therefore thereafter owned in common by the unit owners, right? That sounds a little bit more like it's done, it's finished at that point.
Okay, but so what? If that's it doesn't matter whether it's a fait accompli, a done deal, or subject to for some future act. That's not the important part. The important part is that it's a condition. And my argument below was very clear, and it is before this court. It's a condition preceding.
What about the fact that the instrument ought to be recorded? I mean,
what?
the first sentence here talks about recording the instrument terminating the condominium property. I mean, once it's recorded, counsel's argument is it's done. Isn't that an indicator that it's done?
But if it's done, it's got to be done before you can terminate. Their argument is basically that they have the right to jump to subsection B and just simply not go through A. Ignore
But your argument is that A is kind of a precursor to termination.
A
right?
has to be complied with. It's a condition
But
preceding.
A doesn't actually terminate under your argument. It's a precursor to termination, correct?
Okay,
Is that
but-
your argument?
No, I've got two arguments with respect to that. It could be interpreted to be a prelude, or it could be considered a done deal. And I've argued it both ways in my brief. If it's a done deal, and if it's terminated, then you go back and you say, well, at least 75%, it might be redundant, the way you're interpreting this, but 75% of the owners now want to elect it to terminate. They're entitled to go ahead and have an option to buy the other
Supposed
units.
to try to give meaning to every, provision?
Say that again?
Aren't we supposed to give meaning to every provision? So this beginning part of B, I mean, are we supposed to just say that's redundant and doesn't mean anything?
No, well, I think what you ought to look at is the first part of B. It says, if the owners of at least 75% of the common elements elect to terminate, they shall have the option to buy the apartments. It doesn't have, they have the right to terminate the condominium. So you propose, you assume, I guess, that it's already been terminated or something else applies. But it doesn't say how you're going to terminate it. It doesn't say what you're going to file on it.
But under A, if they've already terminated,
Right?
then you get to B and they say if 75% terminate again?
That's where you go back to Article 15 and you look where they use 75%, and there might have been some misdrafting at that point. But you cannot just, what you would do if you allow this to stand is basically eliminate A. Because why would a unanimous consent of the mortgage holders and the unit owners have to be complied with if in fact 75% can do the same thing? Why would that?
Because 75% can only be achieved by the owners of 75% paying money to the owners of 25% or less, whereas under A, no one pays any money. It's just 100%, and everyone's got a,
But
it's
Judge,
terminated, but they're tenants in common.
But Judge, paragraph B has to do with an option to purchase. That's the option to purchase. It's a totally different subject matter.
That's why he's saying that you would use A instead of B.
Yeah, your question was, why would you have B if you have A, or why would? And I'm just suggesting under A, if 100%, including the mortgage holders, terminate, then the remedy is the condominium's terminated, and everyone's a tenant in common with whatever interest they had before. But under B, you don't need 100%, but on the other hand, you got to pay money.
No, but you don't, but Judge, you have first of all, it's not an obligation to pay money, it's an option. And it's an option that they would have, 75% of the owners would have, to go ahead and eliminate a unit owner without regard to the mortgage holder. That is unreasonable. So they don't have to consider the mortgage holder that was considered by the drafters of the declaration in paragraph A. They said the unit owners and holders of all liens. So now we've forgotten about all the liens. We've totally thrown away subsection A, because nobody's going to go comply with unanimous consent when there's 75% that's only needed. So you're basically nullifying subsection A totally. You're erasing it from the declaration, and you're saying the declarations were drafted to mean that at the time that they signed the declaration, 75% of the unit owners could get together and buy the other unit. They don't have to buy it. This is an option. Subsection B is an option.
But as far as the mortgage holder under A, the mortgage holder's interest is being changed. It goes from an interest in a mortgage on a condominium unit, and it goes to a mortgage on a tenants in common property. It changes their interest. On the other hand, under B, if the whole unit is sold, then it's no different than any condominium unit owner selling property to someone else. Either the mortgage stays with the property or you pay off the mortgage at closing.
But Judge, the subsection B is an option for those people, and it doesn't have to be one particular 75% holder. It could be just 75%. That means 300 units or 100 units or 50 unit owners deciding, okay, we want an option to buy some other person's unit. And now we don't even have to, we're given under subsection B the alternative, that we don't even have to pay attention to their mortgage broker. Like, for instance, so if the fair market value is $60,000 and they've got a mortgage for $150,000, you're forcing them to sell that unit to the other 75% holder. On top of that, you don't know who's going to get the unit, because in this case, it's one person that holds more than 75%. But it doesn't have to be, because the way you're interpreting subsection B, 75%, 75 different people can then decide to exercise that option. It doesn't make sense. There has to be, you are nullifying subsection A if you give it that regard, and you're reading more into B than it's there, because it doesn't say anything other than elect to terminate. It doesn't say a procedure to terminate. It doesn't say what you have to do to terminate. And if the only way to read it would be that subsection A has been complied with, because subsection A says, shall be deemed to be subject to termination. That's their language. In other words, it's not going to be subject to termination unless you comply with subsection A.
Thank you, counsel.
But
Go
if
ahead.
they've done everything else that they had to do, if all the unit owners and all the holders of all the liens and mortgages had recorded that instrument, what else would need to be done to terminate? Why would we go to the being subject to termination? Wouldn't it already be terminated upon the recording of that instrument?
Because that might have been, that's the problem. And the problem is that that's a subject of interpretation now, because it wasn't specifically spelled out. But it was specifically spelled out that subjecting the condominium to termination needed to comply with that agreement of all, unanimous agreement that's referred to on Article 15, where they talk about major repair. And they have the language there that says you can terminate not by going through the agreement, so you're going to give no effect to that language, going through that agreement, and the only agreement I represent to the court, referenced in that paragraph, Article 15, would be Article 17, and that's subsection A. So it always refers to the agreement, so you have to travel through A to get to B, and for them to just pull it out of the thin air and fabricate it as a standalone option to purchase, if you're asking me questions, what happens then? Think about all the questions you would ask. How are we going to terminate? It doesn't say it in subsection B. It doesn't say, does it have to carry, you got to set a meeting, and what do you do? Subsection B has to do with an option to purchase. Subsection A has to do with a subject matter of termination. And you don't get to B without going through A.
All right, any other questions? Okay, thank you, counsel.
And thank you for your time, Your Honors, greatly.